Welcome, everyone, and thanks for joining us for the first of the terrific panels we'll be holding this week on the key law and policy challenges facing our nation. And thank you to our generous sponsors for supporting our important work throughout the year, including, of course, this convention. Just a couple of items before we get started. First, I encourage you to download and use our new convention app, which lists details on all of this week's sessions, speakers, and gives you the opportunity to engage with speakers and each other through the app's networking features. You should have received an email with instructions for downloading the app prior to this afternoon. Also, for those seeking CLE credit for our panels this week, we will post a link in the chat box on the right of the screen at the end of the session. This will take you to the required Google form with all the requested information you need to obtain CLE credit. A password to access the form is required, which will be provided at the end of the session as well. You will need to fill out the form for each panel for which you are seeking credit. Now, it is really my great pleasure to introduce a good friend to ACS and someone who may look familiar since he's been gracing your television screens with some frequency lately, Ron Klain. Ron served as the White House Ebola Response Coordinator from October 2014 to February 2015 and was Chief of Staff to Vice Presidents Joe Biden and Al Gore and to Attorney General Janet Reno. He is a former ACS board member and currently serves on the ACS Board of Advisors. Today, he's going to offer his thoughts on how law and policy are meeting the current public health crisis, and then he'll facilitate a conversation among his esteemed fellow panelists. Without further ado, Ron?
Well, Russ, thank you. And on behalf of so many who care about ACS, I also want to thank you for taking on the leadership of this organization and making the valuable contribution you're making to advancing the work of ACS and the cause of progressive constitutionalism. So thank you, Russ. Thanks for having me. More than 20 years ago, I was fortunate to be the first outside speaker ever at an ACS convention in the wake, ACS meeting in the wake of Bush v. Gore. And so it's fitting to be here today, 20 years later, as we have this first virtual panel at an ACS convention. As Russ mentioned, I have great panelists to call on for their wisdom. I'll get to that soon, and I'll also tell you how you can participate in this discussion. But first, Russ and the team at ACS asked me to offer my thoughts about the pandemics and the law at this critical moment. I want to go back to October 27th, 2014, a Sunday night. I was a week into my job as White House Ebola Response Coordinator, and we were 4 days into the treatment of the first ever Ebola patient in a global megacity. Dr. Craig Spencer, who had taken ill treating Ebola patients in West Africa, had come back and was now being treated himself at Bellevue Hospital in New York. I talked to the CDC team on the ground every day since Dr. Spencer had been at the hospital, but I decided to call the hospital's chief administrator that night just to check in and see the federal government was doing all that it could to be helpful. I expected him to ask for more gear or more tests or more medicines. But when I talked to him, he told me, no, all that was just fine. The government had done its part on that, all that. I said, well, what can we do to help? And surprisingly, he said to me, well, we need legal help. Why? I asked. Well, he told me that the nurses involved in treating Dr. Spencer were being threatened with eviction from their apartments out of fear and stigmatization. Efforts to transport the medical waste being generated in the treatment of Dr. Spencer, because New York did not allow incineration of that waste, efforts to transport that to an incinerator in another state were meeting with objections. Could governors impose intra-state restrictions on interstate waste transportation? And the children of hospital workers were being expelled from school out of fear that they might have the virus or might be exposed to people with the virus involved in treating Dr. Spencer. What rights did they have? The list went on in the weeks ahead. Would vaccine makers who tried an experimental vaccine be liable if patients were injured? Who would own the intellectual property from those tests of the experimental Ebola vaccine? The pharmaceutical companies, the countries in which the tests were conducted, the patients, some combination of all of them. What policies govern the screening and quarantining rule for passengers coming from West Africa to the United States once they left U.S. customs and were technically on city or state property? Could a hospital that was treating an Ebola patient, a private hospital, refuse entry to the Centers for Disease Control staff that wanted to oversee and supervise that treatment? From start to finish, so many aspects of managing that epidemic response involved hard legal questions. And we're seeing that again with COVID, but even more so. Already, the U.S. Supreme Court has handed down an order denying injunctive relief against the California social distancing restriction as applied to churchgoers in that state. A Texas court's ruled that fear of COVID is not an adequate basis for obtaining an absentee ballot in that state. Amazon employees have sued their employer, saying that lack of safety on the job resulted in them bringing the disease home with them and seriously infecting family members. Edicts in Ohio, Texas, and Oklahoma and elsewhere tried to ban abortion under the guise of halting elective surgeries during the COVID crisis. The president has asserted and withdrawn various claims of authority over the opening and closing of businesses and religious institutions. We're going to discuss these legal issues and many more with our wonderful panel today. But at the outset, I want to frame this conversation by talking about why there are so many difficult legal issues in this pandemic response. Why is COVID in the law coming to a law school near you soon? And no, it's not just the latest illustration of Tocqueville's timeless nostrum about how all questions in America become legal and judicial questions. There are three specific factors at work here that are contributing to this epidemic of legal issues around the pandemic. First, while the virus is the product of nature, virtually everything about who has gotten sick and who has not, who has gotten effective treatment and who has not, who has been put at risk and who has not, who has been spared exposure and who has not, these all are the products of the society the virus has encountered and the policies that govern our society. Indeed, in America, the virus has encountered a government in the hands of an incompetent president who delayed and bungled the response, a society where inequality based on race and income is pervasive, a healthcare system that's uneven and inaccessible to many, a public health system that is wildly underfunded, and an economic system where many workers have few or no rights. These are legal questions, and they have had a profound impact on the epidemic in the United States. Second, there are the unique aspects of our governmental structure, our highly federalized systems, especially after a general abdication of responsibility from the White House. Back in early March, before the shutdowns and the broader public attention to this, I was interviewed by friend of ACS, Chris Hayes, on television. And he asked me if I was worried that Trump would use the COVID threat to aggrandize power to himself. I said, no, what really worries me here is that Trump will walk away from the problem. And here in the 21st century, we're going to be left with an Articles of Confederation response to a global challenge. And that's just what we've seen. 50 states, 50 rules, 50 sets of policies, 50 states fending for gear and equipment and all those things we needed. That's hampered our response, and that's created a lot of legal disputes too. And third, and perhaps most significantly, while doctors, nurses, and researchers are the ones who beat diseases, policy, people, and public health are what beats pandemics. There's no question that any competent administration would put in the hands of scientists and medical experts the choices of which strategies we would use to fight a disease, what treatments and medicines are effective, and no, bleach is not one of them, and how to develop a safe and effective vaccine. Those are medical decisions, but turning that medical wisdom into public action is the work of policymakers and public health leaders. Medical experts can recommend mask wearing or stay-at-home orders, but public policy has to decide whether to compel it and how to get compliance with it. Researchers will hopefully find a vaccine for COVID, but policymakers will decide how to manufacture it and distribute it, and public health experts will have to win public acceptance of it. All these are legal questions. When it comes to a pandemic, the legal debates aren't theoretical or abstract. It isn't merely a philosophical divide between different points of view. These are questions of life and death. So hopefully today we can learn more about how progressive legal thinking and advocacy can help us all make the right choices. And so now it's my pleasure to kick off our discussion with our panel. Before I do, I want to say a word about audience participation. We encourage you to be active participants during this panel. First of all, you can tweet about it with hashtag ACS 2020, or you can pose your own questions to the panelists. You can do that on the live comments section on YouTube, located on the right side of this page, or via Facebook if you're watching here. You can share your remarks or your questions. We're going to be selecting some of those questions during the final section of this conversation to ask our panelists. So please do note that in order to comment, you're going to be logged into either Facebook or Google. So with that, I'm going to introduce our first panelist and ask him some questions. I'm going to give brief introductions. The full bios of all these individuals are on the ACS convention website. Our first panelist is Steve Vladeck. He's argued cases before the Supreme Court. He's CNN's Supreme Court analyst. He's a co-author of a leading national security and counterterrorism casebook, an elected member of the American Law Institute. He is the host of the popular National Security Law podcast, a graduate of Yale Law School, and a member of the ACS Board of Academic Advisors. Welcome, Steve.
Thanks, Ron. Great to be with you.
Steve, I want to talk with you about the question of the executive branch and its powers here. President Trump often likes to talk like an absolutist in his view of executive power, but really the distinctive feature of this response has really been a lack of assertion of federal power in many respects, a real failure to use the Defense Production Act, the Stafford Act, other tools that the president might have used in this response. Why do you think that's so, and how would this have worked out differently if the president had made use of some of these powers?
Yeah, I mean, Ron, it's really one of the interesting things about the entire federal response is, President Trump has this remarkable ability to claim powers he doesn't have. For example, the power to override governors and local mayors and other county officials with regard to shelter-in-place and stay-home orders, while not exercising the powers he clearly does have. How could things have been different? What might have unfolded differently? Why has this been so problematic? Well, let's talk about the timing. So, Secretary Azar, the Secretary of Health and Human Services, declares a public health emergency in response to the COVID crisis on January 31st. President Trump himself declares a national emergency under the National Emergencies Act on March 13th. And yet it's not until April that we actually see the first really aggressive exercise by the federal government of any of the emergency authorities that Congress has delegated to the president over time. And, Ron, you mentioned the Defense Production Act. You mentioned the Stafford Act. I'd add two more. I mean, I think the other two of what I tend to think of as the big four of public health crisis authorities are the Public Health Service Act, which is where CDC, for example, gets most of its authority to quarantine and to otherwise take coercive steps to try to prevent or at least slow the spread of a communicable disease. And something that's actually back in the news for all the wrong reasons in the last week, the Insurrection Act, which is the federal government's authority to use the military, if necessary, to help ensure that these measures are carried into fruition. And Ron, for why we didn't see more aggressive uses of these authorities, I think there are three different reasons. So the first reason is I think there's actually a little bit of hostility to the principle behind some of this reluctance. So this is a president, and this is a president staffed by and surrounded by advisors who are generally quite hostile to the idea of government intervention in the private sector. And especially when we're talking about the Defense Production Act, that's very much the model that the statute contemplates. It's not, as it's often caricatured on especially right-wing media, nationalization of industry. That's not what the statute provides, but it is allowing the government and specifically the relevant federal agencies, whether it's CDC or HHS or even the U.S. Department of Agriculture, to actually take a much more aggressive role in the structure of private contracts, in prioritizing private contracts, in identifying particular goods and commodities that are priorities for production over other priorities. And so I think part of what we saw, at least initially, was a reluctance on principle to have the federal government assert such a muscular role vis-a-vis private industry. The president said when pushed on this, that he'd much rather these things get negotiated the old-fashioned way, which I think has the upside from his perspective of letting the market do what it's supposed to do, but the downside of taking time. I mean, we saw how long it took for the government to reach any kind of deal with GE for the production of ventilators, ditto for the acquisition of N95 masks. So I think that's problem number one, is that there's at least some degree of hostility in principle to that kind of aggressive federal role. Problem number two is that I think alongside that hostility to principle was also a fervent desire on the president's part to actually not bear responsibility. That is to say that, the more quickly he had invoked these authorities, the Defense Production Act, the Stafford Act, the Public Health Service Act, the more that the federal response to the crisis would really be centralized in the White House. I mean, Ron, you know as well as anyone that kind of coordination is usually critical to having an efficient response, so that you don't have actors tripping over each other and competing for the same supplies. But of course, at that point, then the White House owns it. It's the White House that's calling the shots. It is the president where the buck stops. I don't think it's going to surprise folks that this is a president who would much rather blame others when things go wrong than actually be the one who really asserts himself as the leading authority and therefore the leading source of responsibility. And Ron, I think the third piece of this, and this may be sort of a little bit further into the weeds, is that in addition to the president's own sort of principled opposition, in addition to his more sort of, I think, personality-driven reluctance, I think there was also the broader politics of this. That from the president's perspective, from the White House's perspective, insofar as the crisis was, unfolding in especially identifiable blue states, it was easier to try to sort of avoid a massive federal response and make it look like it was a problem limited to those jurisdictions. So I think it's a combination of all three of those factors that got us to where we are.
Interesting. It's fascinating to point out, Steve, that the president's reluctance to invoke the Defense Production Act hasn't been there when it's come to the Southwest border. He's invoked it dozens of times to procure body armor for drones, other militarized equipment for the Southwest border. So apparently only COVID was a special case in that regard.
And and Ron, out of sight, out of mind. I think the last major invocation of the Defense Production Act before the COVID crisis really blew up was in late February, when the Defense Department asserted broad authority over something called titanium sponges, and no one noticed. And so I think there's a big difference in general, Ron, but especially I think in this administration, between exercises of power that are very public, and for which there's going to be a clear reckoning, and exercises of power that really are behind the scenes. And I really think that the defining feature of the federal response to this crisis has been to repeatedly look like the government is doing stuff, to have the president go on TV and say, I'm signing another Defense Production Act proclamation. But when you actually read the text of these documents, it is always deferring to the private sector, to local and state officials, and so on, where the president is repeatedly claiming all of this power, but not using it for all the reasons we've talked about, and with the obvious consequences you've already alluded to.
Great. Well, thank you. We're going to come back to you, Steve, but I want to move on right now to Michelle Goodwin. Professor Goodwin is a nationally recognized advocate for civil liberties and civil rights. She's at the forefront of health policy discourse. If you have read anything in the past few months, you have read something by her someplace. She's an elected member of the American Law Institute, an elected fellow of the American Bar Foundation, a member of the ACLU Executive Committee and National Board. So, Professor Goodwin, thank you for joining us.
It's my pleasure. Thank you so much for joining us.
So you've written recently that, quote, government infringement on civil rights and civil liberties should be driven by science, confirmed by medical evidence, and tailored to address health harms and threats. So what government restrictions over the past few months, stay-at-home orders, mask-wearing orders, return-to-work orders for meatpacking workers, which ones have met the standard and which ones have failed to meet the standard?
So historically, dating back more than a century, the Supreme Court has made room for local municipalities to protect public health and safety. We see that in vaccination. We see that even in sheltering in place orders. In fact, one commentary from this period of time has been Gavin Newsom here in California, very early on, issuing shelter in place orders, which maybe to some degree spared California from experiencing some of what New York did just by the moment of doing that. But what we also know is that even with that kind of authority to protect public health and safety, and that's a very important power to be able to use effectively during a time of a pandemic. Sadly, we also know historically that pandemics health crises have been used as proxies for discrimination in the United States. So I want to get to your point about meat packing. What's been unfortunate there has been this real challenge of either work or if not to work, especially for people who are, there's a disproportionate number of Latinos who are working in meat packing in the United States. And those facilities have not been kept safe. In fact, some of the most kind of horrific spikes that we've seen in the United States have been within the meat packing industry without the appropriate kinds of protocols put in place to help the individuals who are suffering there. And it's really kind of a double or a triple whammy in some regards, because we've also seen meat packing industries as the places in which ICE targets. So, thinking about the incredible stressors there, including the fact that because of the way in which the federal government has operated itself vis-a-vis ICE and et cetera, individuals who may want to actually seek out medical care may be discouraged from doing so with fear that perhaps ICE may be alerted or things like that. And so we've seen some horrible ultimatums play out during this pandemic, whether we're talking about Wisconsin and voting, we're talking about meat packing in Iowa or Pennsylvania. There hasn't been the kind of health and science stewardship to govern this crisis in the way in which it should. And basically what across many of my esteemed colleagues on this call will probably say is that the kind of infrastructural and institutional problems that predate COVID, we see now playing out or falling out during COVID.
It's interesting how you talk about the kind of otherization of those meatpacking workers. There was a state official who said, we have no cases of COVID in this county except for, those meatpacking people.
Who are treated as invisible.
Who are treated as invisible, yeah. So I want to ask you a follow-up question, though, Professor, which is, what do you think the Supreme Court's decision to deny injunctive relief to the California objectors to the stay-at-home orders as they apply to religious observance in California, in South Bay United versus Newsom, what do you think that tells us about how these restrictions are going to play out in the courts in the weeks and months ahead?
Well, we're still seeing that, and it may differ. You've asked a great question there. It may differ by state. We've seen a very politicized Wisconsin Supreme Court in the wake of what can only be described as very clear partisanship within the context of their Supreme Court and how they've handled questions with regard to governor authority. Very different in California when one looks at the composition of the court here, state court. Also very interesting to look at the Justice Roberts' response between both the Wisconsin case versus the California case. I mean, what we want is deliberation on these issues that's not polemical, that's not partisan, but that actually pays attention to health and safety, to the data that we have. And there is a distinction between, there's just a clear distinction between people gathering in ways in which they can cause harm or injury to themselves, such as the gatherings for religious observation, and that compared to governors attempting to keep people safe by imposing the sheltering in order orders. What is very interesting is that some have said, well, there is, you can't prioritize one particular aspect of the Constitution over another. And I would say that that's actually not true, that there is no historical foundation within Supreme Court jurisprudence that would suggest that at all. And dating back more than a century, we've had very clear Supreme Court rulings with regard to what exactly it is that a municipality or a legislature can do in terms of protecting public health and safety. And that is paramount. Now, of course, this plays out in very unique ways given the protests that are taking place in the United States right now. And so that adds an additional layer to this. But before we go from my segment, I do want to just emphasize one point, and that is, one thing that's important to note is that within this context, governors using this kind of proxy of pandemic for infringing on rights is something that we can't ignore. We see that within the context of women and reproductive health and rights, with more than seven or eight states that imposed restrictions on abortion rights because of the pandemic. The majority of those have been struck down, but it's very clear that that was political machination, an attempt to harm the rights of others, including in the medical context.
Great. Thank you, Professor. I'm going to come back to the question of those 7 states and abortion restrictions a little later on. But something else you said is a great segue to our next panelist, talking about how the courts in Ohio and Wisconsin struggled with the election administration issues. Brings me to our next panelist, my friend Dan Rodriguez. Dan's principal area of academic work is administrative law, local government law, statutory interpretation, constitutional law. He was the dean of the Pritzker School of Law at Northwestern. He's still obviously an academic there. He's held many other academic posts, president of the Association of American Law Schools, and currently the chair of the Council of the American Bar Association Center for Innovation. So Dan, welcome.
Thank you, Ron. Pleasure to be here.
You spent a lot of time thinking about studying the courts. On the one hand, we've seen the courts respond pretty innovatively on the process issues here, holding virtual hearings, the Supreme Court holding the first ever live broadcasted telephonic hearings, all this kind of technological procedural innovation. On the other hand, as Professor Goodwin alluded to, we've seen the courts struggle to really deal with a lot of the substantive issues, and particularly the courts in Ohio and Wisconsin kind of get kicked around the issues of holding elections there and the defiance of local authority. So how do you think the courts are doing, and what aren't they doing so well?
Well, I want to get to that. Thank you, Ron, for having me here. I hope I won't embarrass you of saying thank you for your service, as among other things, the Ebolas are. We need you now, but that's not your question. So on the one hand, on the other hand, let me briefly say on the one hand, on the positive side, just to really echo what you said, which is we've seen some extraordinary adaptations by the state courts and by the federal courts. Who would have thought in our lifetime that we would have seen the Supreme Court leapfrog over the question of cameras in the courtroom to actually live hearings and telephonic proceedings? So credit where credit is due to the court's willingness to step up generally and to really honor the individual's day in court and civil justice and criminal justice. Hope that'll continue. But let me focus on the other hand, which is the ways in which the courts are struggling. And you mentioned voting. I'll come to that. But I think as from a broad sense, courts really are struggling. And I want to focus in particular on the state courts. They are seeking to balance, and Michelle alluded to this, a century-old precedent, the Jacobson case, right, that established the proposition that in the case of pandemics and emergencies, state and local authorities really do deserve an enormous amount of deference in these emergency settings. But as has been written, Steve Vladeck on this panel has written about this with others, is that doesn't mean that our rights are suspended during periods of crisis and constitutional emergency. And so hence the struggle of courts of trying to balance the interests on the part of the government officials to really address this pandemic with our civil rights and civil liberties. Let me begin with this observation, and actually borrowing from a rather well-known statement that a leading political scientist made about Congress a number of years ago. When we talk about the judiciary, they are a they, not an it. Right. And so we're talking about many judges spread throughout the United States and the federal state courts that are going to be deciding issues inevitably differently. So I'd say 3 things briefly on that. First, to make what I think is an obvious point, but a point that shouldn't be neglected in this, is different state courts, different states have varying standards, have varying constitutional provisions and statutory provisions. That means the kinds of issues that are teed up and will be dealt with by the state courts will by and large be framed by the unique statutes and in many respects, unique constitutional provisions. So for example, many state courts are dealing with issues of separation of powers, right? Where how much authority does the governor have to issue a shutdown order through an executive order versus how much authority and input should the legislature have? And those decisions are difficult under the best of circumstances, but particularly given that states do have their own regime and systems of separation of powers. There are issues of the relationship between state and municipal authorities. We didn't see the court in California deciding the case involving Elon Musk and Tesla You recall that Musk and Tesla were making the argument that Alameda County did not have the authority to shut down the Tesla factory because that case was settled. But had that case gone to the court, there would have been some very difficult decisions, somewhat unique to California, about how much authority there is balancing state and local issues. All states are dealing with, in connection with the shutdown orders, the line between so-called essential and non-essential services. But to be clear, there's not a national definition of what is or is not an essential service. So you have 50 state courts dealing with these issues in a variety of different contexts. We'll see a myriad amount of issues come up. They already have come up, but even as the curve is flattened, thank God, we'll see some challenging issues in employment law, the right not to work, and how state courts are dealing with those surveillance issues. But that's all to make the point that there are different standards and different sources of law. Second, briefly, and I can't really add to Michelle's great comments in this regard, is there are factual disagreements in circumstances, and the role of science and public health looms large. And courts are not completely unequipped, but ill-equipped to deal with some very difficult matters of public health and science, particularly given disputes that arise in the scientific community. And lastly, again, echoing the conversation you had with Michelle, we have the partisan nature of the state judiciary. Most of our state courts consist of elected judges, and in many states, like Wisconsin and Ohio, they're elected in partisan elections. And so it is dispiriting, to say the least, that many of these key decisions are made on the basis of judgments that the public can well understand to be partisan and politically partisan in that respect. I'll just conclude by just saying a couple words about federal courts intervention, which by and large have been interstitial and fairly rare. There will be some key issues that arise. The issues of voting and access to the democratic process are likely to continue, particularly as states might make determinations to have absentee ballots and the like. So although the federal courts have not been front and center in these disputes, they're likely to become front and center. And that leads me lastly to the Supreme Court. The Supreme Court has very rarely intervened in the last few months in these matters, but we are likely to see inevitably the Supreme Court get involved in some of these disputes, and those raise its own dynamics, political dynamics that speak for themselves.
Great, thank you, Dan. Really great summary of that, and a lot of good topics for us to pursue as we move through this. I do want to bring in now our final panelist, Tracy Mears. Professor Mears is a nationally recognized expert on policing. Her research focuses on how members of the public think about their relationships with legal authorities, such as police, prosecutors, and judges. She previously served as the Max Pam Professor and Director of the Center for Studies in Criminal Justice at the University of Chicago Law School. Professor Mears, thanks for joining us.
Hi, how are you? It's good to be here.
So obviously, we are in the middle of a urgent national conversation about policing and police practices as a result of the murder of George Floyd. But before that, we were also in a conversation about how COVID was going to change our criminal justice system. The release of some people from incarceration, the change in certain detention procedures around the issue of COVID. Do you think that COVID will be a driver of long-term changes in the way in which we deal in our criminal justice system? Or do you think this was just kind of an emergency response that has no long-term impact?
Well, how about I hope so? I think the first thing I want to say is in response to your point about before we were in the moment we're in now, which is, I hope, a moment of fundamental reconsideration of what policing is for. As Tom Tyler and I wrote in a piece published in The Atlantic yesterday, I would say that our points, the points we made in that piece, are actually not before COVID or after COVID, it's COVID. They're all intimately related. And they're intimately related because we know that participation in the criminal legal system is fundamentally tied up with all of the issues in communities such as weak social safety nets, poor public health, poor education, no lack of access to good housing, and jobs that actually pay a living wage that cause teenagers in some families addressing the COVID issue to be the essential workers that actually support their families. All of those things are connected, have always been connected because of the way this country has failed to invest primarily in race and class subjugated communities for hundreds of years. That was a point that the Kerner Commission made 50 years ago, and it is just as relevant then as it's just as relevant today as it was then, sadly, right? So we start there, and then you ask the question about whether some changes we saw in an emergency context are they likely to be lasting? Changes we saw, such as jails reducing their populations by huge amounts because of the impossibility of corrections facilities to be able to maintain social distancing, or prosecutors changing their charging practices to avoid sending people to jails and prisons so that there wouldn't be any pretrial detention. That is, of course, going to expose not only the people in the detention facility to COVID, but also their families and the people who work in those facilities. I was recently on a conference call sponsored by the MacArthur Foundation in connection with their Safety and Justice Initiative, and we could see some initial data showing that there have been substantial decreases. You can actually see it in counties across the country. Do I expect that they will be maintained? I actually have reasonable hope because of the combination of the fact that COVID is not going away anytime soon, but also because of the protests and the demonstrations that we're seeing every day that are putting extreme pressure on state and local governments to change the way they approach processing of individuals in the criminal legal system.
And Professor, I want to ask you, do you think, now we're seeing a new phase, kind of, if you will, of COVID in terms of it moving outside of more populous urban states to more rural states, to states that are more conservative politically, where we see really the cases going up in places like Florida, but also places like Missouri and other states. How do you see this dynamic playing out there? Will it be different there? Will it be the same there? What do you think is going to happen?
The dynamic of the ways in which the COVID response is impacting the processing of folks through the system. Well, on that note, I actually think, again, that the MacArthur initiative is interesting because there are jurisdictions all across the country in the Safety and Justice initiative that MacArthur is putting out, right? So it's not just big cities; it's also in South Dakota and in smaller jurisdictions across the country. So we are seeing those same results. I think there's a question about how we might think about how policing is going to impact those places that are having less stringent stay-at-home orders, maybe less stringent masking orders, and how that's going to interact with the dynamics that we're seeing in connection with the protests. That is, are we going to see continuation of the kind of policing we saw both pre-COVID and before all of the protests involving relevant to the killing of George Floyd? Are police going to continue to do what they've done before when they're still at risk in coming into contact with folks who may be symptomatic or asymptomatic and have the disease? I think, Ron, I guess I'm pushing back against your question a little bit because it's really hard for me to separate how those jurisdictions that might not have had as strong a COVID response with respect to changes in criminal legal system processing, but also cannot fail to be impacted by the demonstrations that we're seeing every day. We have a 5-fold increase, essentially, in demonstrations today compared to the demonstrations we saw in the Ferguson era. And I just don't see how the conversation about what anyone's doing remains the same.
Well, let's hope so. Let's certainly hope so. We're going to move on to the part of the panel where I'm going to put some questions to the group as a whole. I'm going to call on one panelist to respond first, but then try to give everyone a chance to chime in if they have something to say. So we're going to try to combine a little bit of technological wizardry with some panel conversation here. And I want to start with where my conversation with Professor Goodwin left off, and I'll start with her. You know, conservatives have said that the pandemic is an excuse for social restrictions from big government, mask wearing mandates, shelter in place orders, so on and so forth. But as you alluded to earlier, what we've also seen is we've seen conservatives hijack public health concerns to try to restrict other freedoms, like especially reducing access to abortion in a number of states. So with the public kind of trying to understand all of this, how can we help the public understand the difference between these two very different sort of restrictions on individual freedom?
So the first, it's important to understand the historic use of this trope. And it's a great question. So historically, public health has been used as a racist trope in the United States, a classist trope. You know, protecting the public health was the underlying motivation of eugenics in the United States. You know, eugenics didn't start in Germany. The very platform used by the Third Reich was the one that was based on the model eugenics law in the United States. The thought was that we have to get rid of people who are considered most, morally and mentally and physically unfit because they're polluting. They're polluting the blood supply in the United States, the gene supply. And so we need to get rid of those people. And the way to do it is through states justifying the use of forced sterilization laws. I mean, the very nature of quarantine in this country, which actually predates Jacobson v. Massachusetts, goes back more than a century before that. You know, Ellis Island and Angel Island were both quarantine stations. So understanding that as a platform is really important. So when we look at this today, it's why I emphasize the importance of, are the actions derived by science? Are they driven by scientific information? Is it driven by protecting the public's health? Do we have data that's reliable and credible coming from epidemiological sources that help to back up what the government is looking to do? Because otherwise, sadly, during times where we're not actually even having pandemic, it can be that the government will use, will have discriminatory aims and use a particular time to implement those discriminatory aims. And so we saw that in this time with regard to abortion in Texas, in Louisiana, in Alabama, in Arkansas, in Iowa, and other states. Legislators and governors using their authority, their platform, to try to cripple women's ability to exercise this important constitutional right. And the framework in which they were doing was to say, well, this is not essential. Don't worry. After the pandemic, you can go back and get the medical care that you want, knowing very well that there are other impediments that have been put in place over the last decade or so by Republican-led legislatures. Between 2010 and 2013, there were more anti-abortion, anti-contraceptive lawmaking bills that were either enacted, some didn't get enacted, but more that were done during that 3-year period of time than the 30 years prior combined, so that even when there were governors saying, don't worry, that right still exists for you after the pandemic's over, they know that they've made it very difficult for people in that state who might be in a second trimester abortion to be able to safely get that type of service. And so it's important to keep an eye on this. And of course, this will lead to Tracy. We see during this time the ways in which racial profiling in policing also intensified, right? So the people who were actually being stopped, arrested for violating sheltering in place orders happen to be disproportionately people of color, Black and Latino. Well, meanwhile, there were white guys who were marching in front of state houses with their Confederate flags in Michigan. The Confederate flag has made it there, and with their machine guns. And so it's really important to think about the ways in which the social dynamics, the political dynamics of our country that precede pandemic also play out during pandemic.
Great. Steve, I know you had some comments to chime in.
Yeah, I mean, I agree with everything Michelle just said. I would just add that this is where I think Michelle's points and Dan's points tie together in such a critical and important way, because I think we can only assume that legislatures and governors are going to act that way when circumstances permit and present themselves. The question is, how are the courts going to respond? And how are the courts going to respond logistically, I think, is a critical part of the story, but also how are they going to respond substantively? And, one of the things that's really, I think, frustrated me about the judicial response is that it really has been inconsistent. So we've seen cases where courts have, invoked Jacobson for the idea that they should be very deferential to these kinds of determinations by elected officials during a pandemic. The Fifth Circuit decision in the Texas abortion case, I think, is the epitome of this, but we've also seen it in New Hampshire. Even Chief Justice Roberts, in his really unusual concurrence in the Supreme Court's denial of the stay in the California church case, or denial of an injunction, cited Jacobson. On the flip side, we've seen some of the same courts being hyper rigid in scrutinizing how these shelter-in-place and stay-home orders have interfered with other practices, especially on the religion side, where I think courts have gone well beyond the ordinary skepticism that they have of laws that impinge on religion in the middle of this crisis, suggesting that, we have to be ever vigilant in the middle of a crisis. And, Ron, I think reasonable folks can probably disagree about what the right mindset is. Dan alluded to the paper that Lindsay Wiley and I have written, arguing that courts should just, stay the course and apply normal review. What I think can't be defended is the inconsistency, is the notion that, we're going to be far more deferential when it comes to some rights and far more skeptical when it comes to others. That really smacks of using the pandemic as cover in all the ways that Michelle articulated.
Yeah. So I want to build on that with my next question, and maybe start with you, Professor Mears, on this question. If we see going forward states impose restrictions on mandatory mask wearing in certain settings, mandatory social distancing in certain settings, and those have in places the force of law, what kinds of policing are we going to see around the enforcement of these mask wearing or social distancing restrictions? And will mask wearing become the new broken taillight of the post-COVID era?
This is where the two issues come together, Ron, exactly, where I say we're still in the middle of COVID, because what we have in the shape of our policing today is a context where we have a set of armed first responders trained to use that tool and a screwdriver, a wrench, and a hammer. I'm being facetious, but I'm saying they're just trained to use just a small number of tools, which, for a certain set of encounters like serious crime makes sense. But for a lot of the things that we ask them to do, it just doesn't make sense. So they're ill-equipped. They respond in a way that they're trained. Situations escalate, and the communities that face the constant deployment of these armed first responders to a set of problems that are evident by the COVID crisis that we experience now, problems associated with public health and mental health and lack of education and people not having jobs and people experiencing homelessness. We see the misfit. So yes, I agree with you that I think there's every reason to think that, unless something changes seriously, that it will become the new broken taillight. In fact, we already saw it in New York City, where there was pretty clear evidence of disparate enforcement of face mask wearing in Harlem as contrasted with other parts near parts of the city near Harlem and Central Park. And I also think it's interesting to point out that, these orders that the police are enforcing usually are some order by the relevant executive, the mayor or the governor. You can imagine a world in which all the police do is, drive around with a loudspeaker broadcasting the words of the relevant executive, the mayor or the state governor, saying this is, these are the relevant rules, so on and so forth. People might think I'm making a joke. That is, in fact, what happened in New Haven. Rather than actively enforce such orders, the mayor of New Haven, when the police were called to monitor groups, or if members saw groups congregating in violation of the mayor's order, they drove around with a loudspeaker. And interestingly, people dispersed. It shows that you don't actually need to use force, and in particular, an armed response to get the important public health results we may need to handle this pandemic.
Great. Dan, I know you wanted to get in on this one.
Sure. We've been focusing up to this point in the discussion, and understandably so, on this command and control sort of model of law enforcement and law, what one cannot do. Leave your home, not wear a mask, etc. It's very important in the context of law enforcement and legal regulation to focus on the support and the money in a public health response, right, that is more proactive. So think, for example, of as we're entering to the next phase where testing and contact tracing become such a key part of this dilemma. What we faced as a result of the last few months is the meltdown of state and local budgets, right? And the unavailability of resources. And so in states that have committed and localities that have committed to contact tracing, they don't have enough contact tracers. They have disproportionate, they either don't have enough technology, or more to the point, technology is maldistributed, right, across communities. So when we talk, and I know we'll talk a bit about federalism later, but when we talk about state and local authority, we should not just be looking at command and control, but what we, the people, and what the federal government, the state government can do to lend support and provide assets to these public officials and governmental and quasi-governmental authorities to be able to accomplish these aims.
Great. Professor Goodwin?
Pick up just on that point that Dan was making, because you also see during this time great entrepreneurialism coming from tech industry. And it's important to measure civil liberties against what's also being proposed as kind of these fixes for legislatures, which actually are highly problematic, such as facial recognition technologies being proposed to legislatures across the country, just defeated here in California, but still being vetted in other parts of the country. Faulty technologies, as we know, but these kinds of technologies can be used for harmful means. Because the technologies are faulty, it means that there can be false positives, right, when these happen to be deployed. And we already know with a criminal justice system that does not treat Black people fairly or kindly, the very nature of that kind of faulty technology being deployed by states could be highly dangerous. And so in California, a recent proposal has been defeated, but as other states are thinking about what exactly to do during this time, it's important to pay attention to that particular, to that too. And I just say that, in the wake of 9/11, let's remember what was deployed by federal government, where we had warrantless tracking of people's communications that was later revealed. It's another aspect of what we need to be concerned about during these times.
Great. And now, Professor Mears.
I just wanted to chime in. Both Michelle and I were like, yes, Dan, great. My chiming in was to give 2 thumbs up on this point about the critical nature of state support during this time, and actually to tie it to these calls for defunding and a potential danger. That is, when people focus on defunding without actually thinking about the point that Dan made, the fact that state and locals really need serious investment as a general matter in communities that are marked by violence, but certainly during to respond to COVID, we simply cannot forget the critical nature of state support here.
And I want to build on that point that Tracy's making, which is an incredibly important point, because what we haven't touched on are the disparate death rates. What's been happening and contracting rates of the virus during this period of time, right? So if we look at Native American reservations, very difficult, where it's been very difficult to get water access, many homes that are unplumbed. How are people supposed to wash their hands if they can't have or don't have running water in their homes? There may be pipes, but not the pipes that come into people's homes. Very limited medical resources. We also see the disparities in terms of who in the United States has been contracting the virus and who isn't. You know, people that do essential work, but that are not treated or valued as essential participants in American society. We know that just as a baseline, when we look at care workers at hospitals, 91% actually happen to be women. As a general population, nearly 80% of the caretakers in the United States happen to be women. If we look state by state where there are demands for tracking data according to race and sex, what we know is that in states where there are very limited populations of African Americans, they happen to lead by per capita the death rates in those states. We talked about Wisconsin. Right during the time of the Wisconsin election, though African Americans make up only 6% of that state, they were more than half of the people who had already died from COVID in that state. So as Tracy Mears was saying, as Professor Mears was saying, when we're looking at where and how we distribute resources, we need to actually be really mindful about the kinds of disparities and harms that already pre-exist and pre-govern in our society, so that those resources are deployed in the most meaningful, impactful, and helpful ways.
Great points. I saw a study out today that said that if the rate of death from COVID was the same among African Americans as it was with whites, there'd be 13,000 fewer deaths among African Americans, which is just a stunning number for just a short period of time. I want to do one more question in this section, but I do want to say we're going to move on to audience questions soon. I want to remind people that if you want to submit a question, you can do that through the live comments section on YouTube on the right side of the page, or in Facebook through the remarks and questions there. I want to build on something, though, before we get to audience questions, something raised by Professor Goodwin in her last comment. We've talked about this a little bit before. I know we have no real labor law experts in this group, but I do think one thing that's really come to the fore during this COVID crisis has been the state of workers' rights in the United States. During the shutdown period, many Americans were able to stay at home and reduce their risk of getting COVID only because other Americans were on the job, providing them with the essential services that they needed, whether it's electricity, telecommunications, groceries, energy, all these things. Took a lot of people to make it possible for others to stay at home. Now people are coming back to work, very little right to opt out if they feel unsafe. Professor Goodwin and I discussed the situation of the meat packers being compelled by a federal order to go back to work, whether or not they were unsafe. What do you think is going to happen to the legal protection of workers as a result of this epidemic? Will we see any changes? Will we see any progress, any greater recognition? There's a lot of cheerleading for the frontline workers, so on and so forth, but will the law actually change? Dan, why don't I start with you on this?
Sure. The caveat is quite right. Not an employment law expert, and I don't play one on TV, but I'll make a couple comments. The existing landscape of employment law, to the best of my knowledge, and not just employment law, but tort law and immunity, is not designed, to put it mildly, for the circumstances and situation of the pandemic. So that, back to my theme about courts struggling, I think courts will struggle with existing doctrine in this particular area. Our tort liability and negligence standards are going to be hard to deal with this particular issue, where you can't figure out exactly how folks were contracted the disease. Our medical benefits regime, right? The Americans with Disabilities Act and other statutes are not well equipped to deal with folks who might be in fear of coming to work because of their age and their pre-existing conditions, but aren't yet sick. So that will take some adjustments. Workers' compensation, how you deal with the issue of whether someone actually contracted the virus on the job or not. All of those issues, I think, again, of insurance, of liability, of employment law are going to come to a head. And so at the risk of kicking the can down the road, I think that what we're going to need is legislation and administrative efforts at the federal and the state level to deal with questions of liability, potential immunity, employment benefits and all of that. And that's a tall order for Congress and the state legislatures. But I hope that they'll roll up their sleeves and really think about some creative solutions to dealing with these issues, because you're quite right that they are going to emerge with a vengeance over the period of time, and even after we see a vaccine being developed.
Okay, Professor Goodwin.
Yeah, unfortunately, I always go back to this sort of historic foundations because they lead us to where we are today. And unfortunately, we've seen an erosion of workers' rights in the United States. And concomitant with that, amongst certain populations, we've never necessarily valued their work, right? So some populations do essential work, they are essential, but they're treated as fungible and as disposable. So according to Domingo Garcia, who's the national president of the League of the United Latin American Citizens, one of the points that he's made recently in a publication that was actually not a US-based publication, but one abroad, was that 4 out of every 5 Latinos is considered an essential worker. They're in construction, food processing, grocery stores, farm workers, and so much more. And yet we have, at least when we think about Latinx folks in the United States, also a population that's been targeted by the federal government in the most heinous types of ways. Many of us have that sort of horrific image in the back of our minds of children, in cages and chained and so forth. And so, I think it's really important when we think about a question such as this, as, who is essential? That's something that can be determined by the legislature, right? It could. But I think that as a more important historic backdrop is to see a disvaluing of the people who do this kind of most basic essential labor in the United States, but which happens to be so fundamental to keeping us fed, to keeping literally roofs over our head, and so much more. And there has to be a broader national commitment and a conversation about it. It's being raised now during the time of COVID as a pandemic time, but I hope that conversation actually sustains beyond this time. And sadly, I'm not sure that it will. I hope it will.
And Steve, I just want to quickly get you in on this. I've been among the people who've called for more use of the Defense Production Act to ramp up our production of masks and protective gear and things. But for workers, the DPA is not a happy story.
Yeah, I think this goes back to Ron said something we were talking about at the very top, which is in the Defense Production Act, Section 707, there actually is, further to Dan's comments, an existing immunity provision that basically says private companies, private businesses cannot be held liable by anybody, which of course includes their employees, for actions that they take specifically pursuant to an order issued by the federal government under the DPA. And so, Ron, we heard a lot of talk, especially when President Trump was threatening to force the meatpacking plants to open, about this immunity provision. Again, though, I think this is the disconnect between the authority the federal government has and the authority the federal government has actually exercised, because we haven't seen almost any of those coercive orders, the likes of which would then bring immunity with them. That is to say, part of why there's so much concern, as Dan notes, about potential liability here is because there hasn't been the kind of federal action that would bring that liability shield with it. It's part of why we are where we are.
Great. Well, after many promises to do so, we're now going to get to the part of the program where we take questions from the audience. Again, you can still submit them via YouTube or Facebook. Our first question from an audience member posted there on the screen. Who has the legal authority to decide what is an essential business? What's the legal precedent here? Dan, do you want to start, and we'll go see if others can chime in?
Sure. I'll beat the drum again by saying the answer to who has the legal authority depends on the state. That question is answered state by state. Certainly in all the states, and this would be true if, as has not been the case, there hasn't been a national lockdown order. But what is or is essential services begins with the legislature. To the best of my knowledge, in none of the states has the state set out through legislation to define what is or is not an essential services. Although, to be fair, there are some state laws and administrative regulations that bear on that. The executive orders, by and large, have set out some criteria from the time that the lockdowns began in late March of what is or is not an essential business. Some have been more prolix than others on that particular question. And so back to your question, I think that by and large, in the absence of some serious separation of powers concern, the executive branch, that is the governor, has correctly taken upon him or herself the legal authority to define that. But we're back to the courts in many respects in dealing with these difficult issues. Our constitutional tradition, by and large, enables government regulation to survive so long as there is a rational basis for determining what is or is not an essential business, so long as particular legal and constitutional requirement principles, civil liberties are not being violated. But the issue of whether they are and to what extent will ultimately be a determination made by the courts, the state courts, or in some cases, the federal courts. So I guess the overall question is everyone has the legal authority in the end, although it ends up with the courts. And I'd say very much the same thing about discretionary medical procedures, which your question raised as well.
Steve?
Yeah, Ron, I would just add to that. I mean, I think, at the federal level, an agency that I think very few of us have heard of, although Ron, I know you know pretty well, is the Cybersecurity and Infrastructure Security Agency, which is part of the Department of Homeland Security, or CISA in acronym land. And CISA actually does have a series of guidelines on what it calls essential critical infrastructure workforce. And I know that a number of states, Ron, have chosen to follow the CISA guidance when it comes to who counts as essential, which sectors. And so, Dan's absolutely right. There's no superseding and preemptive federal statute that takes away from individual localities the ability to decide what's essential or not. I think a lot of localities, though, are following the federal model. And of course, one of the questions is whether that model is adequate. Just one last thing before we move on. The president threatened at one point to declare all religious services essential for purposes of, I'm not really sure what. And I think, again, it's worth stressing, the president can say whatever he wants with regard to legal force. That doesn't do anything because the CISA guidance is, at least as applied in this context, optional. States are choosing what to treat as essential. Whether the state is going too far in saying this kind of business is essential, this one isn't, as Dan says, is ultimately a question for the courts. But I think we should keep in mind that there's a lot of follow the leader here, where what CISA has said, and it's been updating its guidance as we go, has really been driving a lot of the decisions at the state and local levels.
Great. So time for our next question from the audience. We are in the midst of twin crises right now, global pandemic and public outrage over police brutality against Americans of color. Do the institutional weaknesses exhibited during both of these crises overlap? Professor Mears, I'm going to start with you because I think you kind of addressed this already, but certainly a good thing to follow up on.
Thanks, Ron. And I'm happy to address it again. In fact, you addressed it in our opening remarks when you said the response to the pandemic looks like the Articles of Confederation rather than anything demonstrating national standards, baseline standards. So, the fact that we don't have a coordinated national response to the pandemic reflects the fact that we don't have a coordinated national response to a basic set of public goods that allow individuals to thrive in the communities in which they live. As I pointed out earlier, this was addressed, discussed, researched by the Kerner Commission 50 years ago, documenting a set of circumstances that, of course, have existed in this country before that point for well over 100 years as it pertains to Black citizens, especially. And I also want to echo something that Michelle said, because of course I'm conscious of the fact that we do have a federal system. So this is not a call for saying that there should just be one national government in this country and not have the states exist or have local governance, but there's so much more that the federal government could do. Professor Goodwin was talking about the appropriate response to health issues. And I would say responses to violence in these communities is a version of addressing a health problem. But when we look to see what police do or how localities respond, they don't follow the three things that she says are critical: science, basic public health approaches, and data. And these are things that the federal government could play an important role in just setting baseline standards that would help us to address the pandemic in the immediate term, but also to address the long-standing problems around policing that are a cause of the police brutality that we've seen.
Excellent. Professor Goodwin.
You know, that was just so brilliantly stated. I also think about the mental health prong of this as well. So as we talk about physical health, and that's really important, especially given how graphic it is what could be described by the body's response to COVID, the body not being able to breathe. Talk about, a kind of running thematic that we see that's been capstoned by the horrific murder of George Floyd, not being able to breathe and dying underneath the knee of a Minneapolis police officer, exclaiming that he cannot breathe. And the question that we have, it is a perfect storm of these matters coming together. And one aspect that we don't deal with, that we haven't dealt with successfully in our country, is really mental health. And it's ironic and interesting. One of the largest mental health facilities in our nation, in fact, it's often called the largest, is actually the LA County Jail. It houses so many people who are in mental health crisis, but that these are issues that have been taken up through policing and criminalization. And if we were to think about just what this kind of criminalization and the criminal policing has produced, especially with the images that we have all now been exposed to, it's a kind of trauma. And it's communities living with that kind of trauma. And at the same time, a failure really at the state level and also the federal level to give appropriate attention to that. I mean, we still have senators, Booker and now Harris, still trying to bring along an anti-lynching bill. And that anti-lynching bill, what it does for all of us is in fact to give some recognition to the horrors that have been experienced by communities of African Americans who, either through knowing directly through their own families or by proxy, those who have suffered those kinds of fates, which really impact us all. So I think it's a really important question. When we think about public health, we have to think about policing, and we also have to think about mental health, because we've all been affected. And I think one way of thinking about the protest in the street is that it has really touched people's hearts and minds in a way that is really dramatic and profound.
Great. Thank you. Very, very, very powerful stuff. I do want to move on to our next listener question or viewer question, which concerns this question of immunity. As state and localities reopen, businesses are asking legislatures for immunity from liability for their workers getting ill. Some of those immunity provisions center on whether or not a particular employer complies or doesn't comply with certain kinds of restrictions. Others are broader grants of immunity. As I said at the outset in my opening remarks, we've already seen one lawsuit from an Amazon employee against Amazon for alleged practices on the workplace that led to the transmission of COVID to his family. So what do we think is going to play out in this immunity debate? Do we think states will pass immunity statutes or not? Dan, what do you think?
Well, a great question. Just a brief point about politics. As we know, Senators McConnell and Cruz and some others on the Republican Party have insisted on some immunity and have, in many respects, held other legislative proposals hostage. I think that's problematic for a variety of ways. I'm generally not a fan, nor do I think we should be a fan of blanket immunity and broad immunity. I think it raises a whole host of problems with respect to responsibility and compensation and all of that. Although I understand not only the instinct, but the need of some balance and some trade-off. I think that as questioner talks about workers and customers, I think those are two different important segments. I think workers there's less a question of employer immunity as there is a question of how our workers' compensation regime provides for adequate compensation for individuals who might contract COVID-19 on the job. Just a very brief note about customers. A colleague of mine, Daniel Hemmel at the University of Chicago, and I have a paper in which we argue with respect to liability for harm caused by customers, or arguably caused by customers. We've suggested perhaps a safe harbor, an incentive for employers, small businesses, like think of restaurants or bars, to contact individuals who they discover have come into contact with others on the premises who have COVID-19. And if they in fact can contact them, that they have a safe harbor and a protection from negligence. Those or any other proposals I think are more promising, quite frankly, than blanket immunity. But I certainly think we'll see some efforts underway at the state legislative system. It wouldn't surprise me if some states make the decision, which I think would be wrong, but to have a more blanket immunity as a quid pro quo for opening up businesses.
And Dan, while I've got you, let's talk about first-year tort law here and causation. So if a worker gets COVID because the employer isn't particularly careful, you can talk about workers' compensation for the worker, but what happens when that person transmits COVID to their family members or other loved ones, and they transmit COVID to someone else, and so on and so forth? What does the chain of causation look like here?
You're exactly right, Ron. It takes us all the way back to our first-year torts, because we know that causation has to be established, right? At some level of plausibility, you might have to convince a fact finder, or a juror, or a judge about that. But I don't have to be an epidemiologist to know that that's going to be extraordinarily difficult given the chain of contact and communication. So we could handle that conundrum of causation in a variety of different ways. We could throw up our hands and say, hey, we don't know how you contracted it. So, not our problem, it's your problem. That seems like a fairly cruel way to deal with it. We could take the opposite effect, which is to say, as long as we can establish that you had some exposure or potentially some exposure at some point on the premises, we're going to assume some chain of causation. And by the way, just going back to the legislative change, there have been some proposals, including one proposal in my state of Illinois, to basically for first responders, for those nurses, doctors, law enforcement personnel, to presume causation. That is to say, in the absence of proof that you contracted COVID-19 in a different place, we're going to presume that you have contracted the pandemic, you've contracted the virus on the employer. So I don't have a really good answer to that, but I think those raise enormously difficult questions of causation by virtue of the nature of the virus and contagion.
Right. I want to move on to our next audience question here. Try to get as many of these in as we can with the last 10 or 12 minutes we have left. Courts have postponed trials, and attorneys have had limited access to clients awaiting trial. Should we expect cases about the constitutionality of these measures that were meant to slow the spread of COVID may have infringed on people's speedy trial rights and other kind of defense rights? Tracy, should I start with you? I'll start with Steve. Sorry, go ahead, Steve.
Thanks, Ron. Thanks for the question. I think that the short answer is not only should we expect it, but we're already seeing it. There's been litigation about some of these delays. For example, there was a big story last week about some judges in New York State who are now basically presumptively deferring arraignments and presentments for more than 24 hours, even though the state law seems to require presentment within 24 hours. Ron, I think the short version is I wouldn't expect that the federal courts, or at least courts applying the federal Constitution, are going to find a whole lot of obvious constitutional problems here, even though we might disagree. I mean, so for example, there's this case out of Ohio where there were inmates in a federal prison who were at a very high risk of infection. A district judge ordered the Bureau of Prisons to take steps to ameliorate that, and the Supreme Court stayed that order. And I think the Sixth Circuit just this morning actually reversed the district court. So, Ron, I actually think that the hot spot for this litigation is going to be in the state courts themselves, where these claims are going to be advanced under the federal Constitution, sure, but also under state constitutions. And given where the relevant bodies of law are at this point in time, I actually think it's much more likely that some of these measures are going to run into trouble under state constitutional provisions about speedy trial, about due process, about speedy presentment than federal ones. At least that's been what we've seen on the ground so far.
Great. Tracy.
I just wanted to add something quick because I wasn't sure that Steve was going to finish with the point about federal versus state, which is exactly right. The federal provisions here are, with application to the state requirements, are very weak. There are all sorts of federal rules, of course, for their own speedy trial issues. It's also important to point out, though, that with respect to the state courts, there are actually court rules themselves that have to either be obeyed or abrogated. And we're seeing some of that activity in municipalities at the county level where courts are actually changing their rules around this. One other thing, of course, rather than litigation, what you might just see is a pushing down such that the different units of the system start changing their behavior, right? So if police actually aren't bringing folks in for custody and prosecutors aren't actually charging people, then you don't get pre-trial detention, for example. That's a different issue from the presentment issue, but folks who are stuck in jail who may or may not be able to talk to their defense lawyers. They can obviously talk to their defense lawyers if they're not in jail, right? And so one of the things we've seen in terms of the COVID response of many different aspects of the system is that there's a much lower, the first people to be released were the folks whose offenses hadn't been adjudicated, who were detained pre-trial for whatever reason, usually, in my view, completely unnecessary reasons, when there are all sorts of other ways to ensure that people show up for their day in court.
Great. We're going to try to get in two more audience questions before we run out of time. The next question comes around the question of abortion restrictions and the role of science, and is what kind of criteria have been considered in determining whether a medically necessary procedure is necessary when we're living under stay-at-home orders. Michelle, why don't you kick us off here?
So this hasn't been well defined by legislatures, but what they have done, and those that I've mentioned that have banned abortion, is to claim that abortion happens to be non-essential, or that it happens to be elective. And what's very interesting is the way in which that trope too has been used over time in order to frame abortion as something very distinct from seeking to continue to gestate, so that there is a primacy that's given to carrying a pregnancy to term versus having a pregnancy that one would choose to end. And what these legislatures have said is that they just don't see it as being essential. But here's where data actually does really matter and should be essential to a conversation like this, which is that women are 14 times more likely to die by carrying a pregnancy to term than by terminating it. If you looked at it that way, then in fact, you might say, well, of course, it's quite essential then, right? If we know that you, by continuing this pregnancy to term, you're 14 times more likely to die. Now, that's data, empirically grounded data. It's not controversial data in that this is, that this is statistically proven and true. In the United States, what makes that even worse is that if you happen to be Black, you're 3.5 times more likely to die by carrying a pregnancy to term than if you are white. In certain states, that's even further exacerbated, where a Black woman might be 17 times more likely to die by carrying a pregnancy to term in that given state. The US ranks 50th in the world, according to the CIA, in terms of maternal mortality. And Texas has been considered, although Louisiana fights right up there with it, the deadliest place in the developed world for a woman to be pregnant. Now, when you think about Louisiana and you think about Texas, these were two of the states that right away imposed restrictions on abortion during COVID. And you have to pull back and you say, well, how does the medical evidence then align against that? The medical evidence actually shows that it's quite dangerous. In fact, and governments know that it's quite dangerous to put pregnant persons in the position where abortion would be denied during that time, given these incredibly high rates of maternal mortality. But even if we didn't look at that, just simply the kind of gerrymandering with abortion rights during this time is a really terrible partisan game that's been going on for a while now in the United States.
Awesome. Thank you. I could literally do this all day, but we do only have time for one more question. And I think we're going to put up the last audience question now. I did compare the COVID response to kind of the Articles of Confederation, but I think it raises a broader question this listener asked, and I was going to pose anyway, about whether or not this kind of devolution of power to the states is going to be a more lasting trend. It's interesting that most crises we've seen in the past couple decades have enhanced federal power, have grown the power of the executive branch, have grown the power of the federal government. This one seems to have devolved power. Do we think that's a new trend or just a one-time thing? Steve, why don't we start with you?
Yeah, I mean, I think it's worth, maybe Ron starting with a really brief note of history, which is, a big animating catalyst for the Constitution itself was the impotence of the Articles of Confederation government, specifically with response to domestic crises. Right, that Shays Rebellion in Western Massachusetts in 1786, when basically a bunch of farmers with pitchforks couldn't be put down by the Confederation government, is part of why we have such a powerful, if limited, federal government today. I don't think we're going to see fundamental structural changes in the allocation of power just by dint of this one crisis and this one response. I do think that this has been an object lesson to every state about the difficulties of relying upon the federal government for crisis assistance. And so it wouldn't surprise me at all if, consistent with whatever budget opportunities they have, we actually see a lot of pressure on state governments going forward to do more of their own disaster planning and to actually, be more prepared to handle these kinds of crises without federal assistance. Not because it's how it should be, not because it's how federal law actually structures this, but because we've seen just how much that, federal umbrella of support depends upon a president who's willing to aggressively exercise those authorities. So, I don't think there's going to be a change in structure. I do think there's going to be a lot more sort of rainy day planning by states to deal with an unhelpful and, very, very wordy but not very effective presidential response.
Great. Dan, I'm going to give you a chance to get in the last word here.
I think whether there's a fundamental change in federal structure with respect to this depends fundamentally on the results of the next election and maybe the next couple of elections. Who the next president is, what Congress looks like, and what happens at the State House. That will tell us an enormous amount about whether this is a blip or a fundamental restructuring of the relationship between state and federal government.
Great. Well, I want to thank all of my fellow panelists for this amazing conversation. I really enjoyed it. Found it really informative, really grateful. I hope everyone follows all the different things we've also posted on the ACS blog during this conversation. We'll continue to post. These issues are we just scratched the surface of so many of them. There's so much more to do and to look at and to think about here in this area, and so much interesting legal development that's going to come, as I said, often with life and death consequences. So I want to thank my fellow panelists. And before I turn it back over to Russ to close us up, I just want to hope everyone stays safe and agitated, active and protesting, and also trying to be as careful about all these things as possible. And I want to say I look forward to seeing everyone in person next year, back at the Capitol Hilton at the newly addressed 1001 Black Lives Matter Plaza. So thank you for joining us. And now, Russ, why don't you wrap things up?
Thank you so much to Ron and to all the panelists for a tremendously insightful conversation and for getting our convention off to such a good start. A reminder for those seeking CLE credit for today's discussion, Please click on the link posted in the chat on the right to access the CLE form. The password is ACS 2020, all caps. We will also provide the link in a follow-up email to all registrants at the end of the week. Please remember that you'll need to fill out the form for each panel for which you are seeking credit. Also, thank you to those who donated to ACS during registration. To those who haven't, there's still time. Please go to acslaw.org. Your support is more important now than ever. I now hope that everyone watching will join us tomorrow for our next panel discussion at 2:00 p.m. Eastern, when we will hear first from Minnesota Attorney General Keith Ellison. Details can be found using the convention app and on the ACS website. We'll see you then.